Little louder be okay. Hey, good evening, everybody. Tonight we have a webinar with Bill-Rattner. And Bill used to be a retired lawyer, and then he went to work for Lawyers for the Creative Arts in Chicago and heads up that powerful and important operation, which helps an awful lot of artists pro bono. I think it's pro bono. We're going to have to clarify that. With their legal issues and sometimes the IRS and sometimes their landlords and sometimes copyright situations, etc. So from a legal point of view, Bill-Rattner is an expert on the kinds of things that artists frequently run into. And he's kind enough to join us tonight to share a fair amount of that information. I don't think we're going to be able to cover anywhere near what he knows, but it'll get our feet in the water, and I think we're going to hit the high points. Bill, you want to say? I'm going to say this. Bill would prefer that we hold questions until the end of the conversation, unless they have a global application. If the legal-based question you're asking is relevant to pretty much everybody in the group, go ahead and unmute yourself and ask the question. If the legal question you have for Bill is really about your particular situation, there'll be time at the end for him to answer your question, okay? Bill, you're on, man. Take it away. Thank you for being here.
Okay, thanks, Paul. Thanks for having me. If anybody cannot hear me, however you let Paul know, let him know. Just for background, I never really retired. I went right from practicing law to heading up Lawyers for the Creative Arts 11 years ago. Lawyers for the Creative Arts is a nonprofit organization, and our mission is to provide essentially pro bono free legal service to all areas of the arts, not just the visual arts, but all areas of entertainment and performance, music, film, theater, dance, everything of that nature. And that's both for individuals and organizations. So give us a call. And we are in Chicago, of course. I want to go right into this. I am quite aware that everyone out there is a professional, practicing, serious artist. And I don't want to be very academic or pedantic or something. Law can be that way. I want this to be of real practical use to you on an everyday basis. So I will try to do that. First, every time I get people together, I probably don't have to tell this to you, but every time I get artists, particularly visual artists, as opposed to musicians and filmmakers, is you are in business. Artists don't like to think of themselves as being in business, but everyone you deal with is in business. They act like they're in business, and if you don't realize that you are, you will get the short end of things. We see that quite a bit with the people who come in, and if they were a little more business-like at the beginning, they wouldn't have problems. I'm not going to make a lawyer out of you. We don't have the time. I'm going to like scratch the surface. What I really want to do is kind of alert you to certain areas that are of concern to you as professional artists, and hopefully give you a few answers to some things. I want to cover just a little bit about contracts. And I want to talk a little bit about consignment of art, dealing with dealers. Then I'm going to spend probably most of my time on various aspects of copyright, because that's what I understand most of you want to hear, and it is confusing. If there's time at the end, I want to talk about something called art as an asset, and then we're going to have a question period. A little bit about contracts. What's a contract anyway? A contract is basically an agreement that creates legally enforceable obligations between two or more parties. If a contract is valid, a court will enforce it. The court will make the parties do what they say they're going to do. And if not, there's various sanctions. there isn't very much required to make something a contract. Basically, an offer, an acceptance, somebody proposes to do something and the other side says, fine, I agree. And then there has to be essentially something called a meeting of the minds. Now the court will look to say, did these parties really mutually understand what they were getting into, and did they want to get into something binding upon them? And then if there's consideration, we can talk all night about that. It's basically each party gives something to the other. Any kind of contract can get very fancy, long. They don't have to be. A bare essentials, and I'm not suggesting you always have to have lawyers or take something out of a form book. Sometimes you're better off taking a piece of paper and scratching out what your understanding is and signing it. Identify the parties. Who are the parties? What's the subject matter? Contract should tell a story. Here are the two parties. What are they each going to do? A is going to do this and this and this, and B is going to do this and this and this. If you're selling something, put in the price, or put in what you're giving up if it isn't money. Put in the time that you're going to do it. I think that if you get just these minimum things, I wouldn't talk this way at the Bar Association, but most of the people who walk into our office who have a problem would have been better off if somebody had sat down and typed out a one-page agreement that says the artist is going to do this and this and this, and the other party is going to do this and this and this. And here's when we're going to do it, and here's when it's going to be delivered, and that's it. And sign it. They'd be better off with even that little non-professional thing than nothing. Now, sometimes when you get a little fancier, you will maybe presented with a contract that has what we call warranties, and they're going to ask the artist to sign something called warranties. What might somebody ask an artist to warrant? A warrant is just a promise regarding the quality or the performance of the subject matter, and the other party can rely upon those. You would think of these if I gave you the time. Who is the printer or the artist? A warranty may say John Smith is the artist or the painter or the printer. That it is an original, if it is. That in selling this piece of work, you're not violating anyone else's copyright. So if I buy your painting or your work of visual art, I want you to guarantee to me that you haven't stolen this thing or copied it, that it is original to you. Sometimes perhaps the materials are important. In sculpture, it might be important what materials you used, or in other areas of visual art, exactly what kind of paint or medium you used. Sometimes the buyer wants to know that the print or the photo is one of a kind, or one of a limited number of what you've produced. Buys something, thinks it's an original, and finds there's 100 more out there, the buyer is going to be upset. Basically, anything that would influence the other party's decision is material to that party. As I said, I don't want to get real deeply into that. What gets into it? A breach of a contract is simply when one party doesn't do what he or she said they were going to do. Courts won't look at trivial things. If it's a little teeny thing, they won't consider that important. Should you see a lawyer? Probably you don't need a lawyer for every agreement. If you're going to enter into a kind of a form agreement, and you're going to use a particular form for lots of people, lots of times, it's not a bad idea to have somebody look at it once and give you a form to work off of, keeping in mind that a form usually has to be doctored or tailored to meet the particular circumstances of each sale. but certain basic provisions, it's worthwhile getting an attorney to give you something if you're going to use it quite a bit. Certainly, if someone is threatening you or saying that you've done something wrong, get some help. You can have agreements with buyers, you can have commission agreements, artist show agreements. Be very careful if you're dealing with art agents and people who are going to represent you. Make darn sure what you're signing up for, whether it's exclusive, whether there's a territorial exclusive, whether or not you would owe a commission if you make the sale directly and not through that agent. Make very sure that it's terminable, that you can say at some point, I'm out of here, how long it goes. Those of you who are in commercial art, we have a lot of people who are graphic artists come to us, not just the fine artists. A particular area of concern with them is what I call overuse. They're commissioned to do a drawing, do a painting, do some kind of graphic work for a particular purpose. We need this for a particular purpose. And later on they find out that the customer is using it for everything. It's all over the internet. It's on everything that person uses. They bought it for a small, cheap purpose, and they're using it for a wide purpose. That is an overuse, and that's a violation of the contract, probably. That's what graphic designers get into. Another thing that graphic designers that we find get into is this. They'll get hired by an advertising agency. The advertising agency will say, the sponsor, the customer wants this and this kind of a program, and we want you to do the artwork for it. You do it. You've done everything you're supposed to, and then the ad agency comes to you and says, well, you know something, the client, changed their mind, things aren't so good, they're not paying me, so I can't pay you. You know, that wasn't your deal. That's baloney. You did what you're supposed to do, you should be paid. If the ad agency takes a hit, that's their problem. We see that sort of thing come up a lot, too. As I said, I don't want to get into a whole heck of a lot more on contracts. If you have interesting questions or something, let me know. I want to get into a particular kind of contract that most of you deal with, and that is in dealing with galleries or dealers. This relationship is typically what we call consignment. Consignment usually means, I know this sometimes happens, but it's not customary, where the artist sells the art to the dealer and gallery, and the dealer and gallery can do what they want. Most often, from what I've seen, it's what's called a consignment. And on consignment, what happens is that the artist gives physical possession of her works of art to a dealer in gallery for the specific purpose of it then being sold to a third party. And the artist and the dealer split the proceeds in some way. So that although the person, the gallery does not have ownership of your art, the gallery has the legal right to transfer ownership of the art from you to the ultimate customer. So it's delivered for the purpose of selling to a third party, and the dealer has your authority to transfer title to somebody else. There are usually no problems with this, and most dealers and gallery owners are honest. They act as mentors, advisors. They are of tremendous use to artists. Like anything else, there are some really bad apples, and we find that it's usually the same ones over and over again. The problem with dealing with galleries and dealers, you know from your own work, it's hard to market art. It's not easy, and I'm sure a lot of the talks that Paul hosts have to deal with art marketing. It's not easy. There are many, many artists and few galleries and dealers. You're in basically an unequal bargaining position. unless you are a very, very major, highly desirable, top-of-the-pyramid artist that every dealer or gallery wants to represent, and by definition that isn't very many, then you do not have great bargaining power with the gallery and the dealer. Gallery and the dealer, you have all heard this, I'm sure, will say in one way or another, nicely or not nicely, perhaps you'd be happier with some other dealer. Go find somebody else. I've got a lot of people, I've got slides here from 50 people that came in this week. Whatever they say, the bargaining power is there. Sometimes they take advantage. Traditionally, some of the problems have been, and again, I want to stress, this is with a very, very few galleries and dealers, not most of them. But the kind of problems that have come up is the artist not being paid, or being paid slow, or being paid part. If you think about it, it's really kind of funny to me. Artists usually think that these dealers and galleries are the richest, boy, they are the top of the heap. These are the richest people in the world. Then you talk to the gallery dealers, and they're all bemoaning the fact that they're barely staying in business. And I had a call from one today that's going out of business. So the gallery dealers don't think they're so rich. The artists do. But when things get a little tough for a gallery or dealer, can't quite pay all the bills, they have to decide, like our Congress was almost about to decide, what do we pay? Well, they got to pay the landlord or they get kicked out. They got to pay the electricity or the lights go out. They have to pay their workers or the state and the federal government gets all mad at them. They got to pay their taxes. Who do they not have to pay? Well, the artist. And so the artist will frequently be paid last, never, part only, etc. You also hear stories of art being damaged, art being destroyed, art being lost somehow. We have no idea what happened to it. Very often, the dealer goes broke. There are stories, Paul knows them, maybe you do too, of the gallery is there, everything's fine. Monday they come, the door is locked, and no one's there, and there's a sign on the door that says closed. Meanwhile, your art's inside. Your stuff is either on the wall or packed in those nice little slots in the back room. And the landlord comes in and says, this no-good dealer walked out on me. He owes me $11,000. Take all these damn pictures, he says to his associate, and let's sell them for whatever we can. That's your art going out the door at 50 bucks a piece or 25, whatever the landlord can get. That kind of thing led to many states to pass special art consignment laws. Illinois passed one about 25 years ago. About 30 or 35 states have some kind of particular written statute that protects the artist in these situations. I don't know where you're all from, but I'm going to talk about Illinois. Your state may have something pretty similar to it if you're out of state. But what it does is it protects the artist. It's very protective of the artist. It's good for the dealer as well, but mainly it's designed to protect the artist. And it applies when an artist delivers a work of fine art for purpose of sale, exhibition, or both on commission, and the dealer accepts it. So typically, assuming that what you have is a work of fine art, and no court is going to get into a big debate as to whether your work is fine art or not. Anything you create is going to be considered a work of fine art, I am sure. Give it to them and say, here it is, sell it, show it, sell it, and we'll split it. That triggers the application of the act. The main purpose of the act is to induce the dealer to give a written contract to the artist. One of the big problems over time has been the lack of contracts. So all those things I talked about usually are the result of there being no contract. I haven't been paid. I told you I'd pay you. Don't get excited. I'll pay you when I have it. Well, there's no written contract that says you're paid within 30 days. It's damaged and destroyed. I'm sorry, it wasn't my fault. The roof leaked. You know, some bunch of kids came in and one of them stole it and ran. Or somebody knocked it down accidentally and broke your piece. The main purpose is to get a written contract from the dealer. There are kind of some sanctions on the dealer for not giving you the written contract. It does not tell you everything that has to go in a contract, but the Illinois statute requires that the contract must contain at least the following: the time within which the artist is to be paid once the work is sold. And you can put in whatever you want, 30, 60, 90 days. If you put in nothing, you must be paid within 30 days. What is the dealer's commission? 20, 30, 40, 50, whatever it is, percent must be shown, and whether or not the artist gives the dealer the right to take certain discounts. So you could well say the dealer's commission is 50%, and on a particular piece or on all my pieces, the dealer has discretion to give a discount of 10% or something, say 10%. If he gives a bigger discount, fine, but it comes out of his share, not mine. What else, in addition to the sale price of each piece? So what you have to have is attached to your contract is a list. You should absolutely have that. Believe it or not, I get people who don't do it. Come in, you should have a list and say, here is a list of each piece I have given the dealer, and the dealer signs it. Number 1 is blue cow. Number 2 is red cow. Number 3 is striped this and that. And each one has 2 figures. First, the minimum sale price. So I want my work number 1. The minimum sale price is $500. My painting number 2 is $700. Painting number 3 is $500. Painting 4 is $1,000. Whatever it is, minimum sale price. Plus, you can say, as I said, if you want, you can discount it up to 10%. The second dollar value attached to each piece is its value, not its sale price, but its value if it gets lost, strayed, or stolen, or destroyed. So what you don't get is the argument if a gallery loses your piece or it's destroyed, you're saying that was a $1,000 piece. And the gallery owner says, no, it wasn't. I was going to try and soak the public for $1,000, but it was only worth $300. To avoid those arguments, what the statute requires is that you put down that value when you give it to them, and there's no arguments later. If it's listed at $1,000, that's its value for purpose of arguing between you. Now, your agreement can certainly include many other things. And if you go on our website at Lawyers for the Creative Arts, I have a piece I wrote a couple of years ago called Dealing with Dealers, and it has a whole bunch of other things that you ought to think about in there. Insurance, exclusivity, whether you're allowed to sell at other galleries. Perhaps there's a geographical, I won't sell anybody else on the north side of Chicago, but I can sell in Milwaukee or Detroit. We talked about commission. What's the duration? How long is our relationship going to last, your gallery and me? When, and not only when do you pay me, but you should get a report every quarter or something of that nature that says, look, you gave me 10 pieces. Here's what happened. I sold number 1 for so much, number 6 for so much, and number 8 for so much. I have all the others. So that both of you always agree who has what. That should come to you in writing. If you don't, go to the gallery every once in a while. Stop in. Say, hi, how you doing? Where's my art? Look around. Is it on the wall? Is it in the back, etc. If your gallery is out of town, you live in Chicago, your gallery is in Atlanta, send a friend in there. every 2-3 months, whatever it is, send somebody in and say, hey, go look for my stuff. Is it still there? Is it still shown? And if I sent them 7 pieces and they only have 4, maybe they sold it and didn't send me the money. Keep track of where your stuff is and how much of it's there. There is no set custom or usage as to whether the gallery will give you the name and address of the buyers. I have spoken to gallery owners in Chicago from the best on down, and the best answer I got was from maybe the finest one gallerist in Chicago, who gave me a very clear, sometimes I tell them, sometimes I don't, and without any pattern as to when. You know why they won't. They're afraid you're going to go around them and deal directly. Others don't. Crating and shipping, who's going to pay? Who has to pick? You have to pick it up. You have to pay from their place to yours. Exhibits and framing. Do they have the right to take off your frames and put on others? Do they have the right to take yours and say, I think this is going to look better framed, and so I framed it, and incidentally, your cost of that is $300? Make sure that you have an agreement with them, whether it's to be framed and at whose cost. Make sure you have an understanding as whether or not your stuff is going to actually be on the wall or just back in the racks in the back. May the gallery lend your work to potential buyers? Who covers the risks of damage and loss if that happens? Promotion and advertising, all sorts of stuff like that. So what else the statute does is very important. I mentioned that art can get lost, strayed, and stolen. No matter what happens to your work. In Illinois, under this statute, if it is given to the dealer, it doesn't matter if there's a hurricane, it doesn't matter if Al-Qaeda blows it up, it doesn't matter what happens, no fault at all of the gallery is strictly liable for that loss. For how much? For the amount of value you wrote in that agreement. So even if the gallery is absolutely not at fault, the law says that the gallery is absolutely responsible for the value that you agreed to.
Let me interrupt for a second there, Bill. In 1989, I had a gallery that was destroyed 100% by fire, and there were about 10 galleries in the building that were also destroyed by that same fire, and everybody suffered a 100% loss. And the Illinois Consignment Act that Bill is referring to had come into existence shortly before that. And I was fortunate enough to, it's a long story, we can talk about it another time. I doubled my insurance the day before the fire. But a lot of galleries were caught underinsured, and they were very compromised by the fact that they had a proper legal responsibility to those artists. So this can be very relevant.
This is very relevant, and Paul has hit upon the one thing that is a big flaw in the art consignment law in Illinois, which if you live in Illinois, you know what the Illinois legislature can do if the right people ask them to do it. And that is, although the gallery is absolutely liable for those things, there is no requirement that the gallery be insured. And so, when people see the Joe Smith Gallery and they know that Joe Smith is a very wealthy person, or Joe Smith's spouse is wealthy, you can bet that that gallery is not owned by Joe Smith, but is owned by something called Joe Smith Gallery, Inc., or Joe Smith LLC, and that corporation may not have money. So even though the gallery is responsible, doesn't mean they have the money to pay. So because the law does not require the gallery to carry insurance. That is a flaw, which leads to the point, make sure when you deal with a gallery, whether or not they are insured for any loss of any kind for your art. If they're not, you have to consider whether you're willing to pay for it.
I think it's safe to assume that 90% of galleries that show contemporary artists have inadequate insurance.
That's probably true. So which means that you, the artists, have to find that out, and if that's the case, you may have to carry it yourself.
Let me interrupt here again, Bill, and then we can move on to copyright. I think, as a gallery, I differentiated between the significance of having a consignment agreement And anytime an artist brought or shipped work to the gallery, they got a consignment agreement that spelled out retail, wholesale, replacement value, you know, the basic direct kinds of things. It did not address whether it was going to be on the walls or not on the walls. And out of about 25 artists with whom I worked, I only had an actual contract with one artist. And, you know, we've got another person after this webinar, Paul Gray, speaking with us, so we can talk to him about his policies. But he's obviously, well, he's not necessarily obviously, but he is a more substantial gallery than most of the, you know, well, he's a substantial gallery, and maybe their policies are a little different. I think it's really important to have a consignment agreement that, you know, discusses what's going to happen with the work specifically. In terms of beyond that, you know, a contract that covers so many situations, I frequently myself feel like it's a question of trust and a personal relationship, and a handshake is sufficient, and Bill may disagree with me, but with that kind of agreement, if you're dissatisfied at any point, you can walk. And I think with a contract, maybe you can't. I'm not sure which gives the artist more power, but I'm comfortable with a, you know, a significant or a sincere consignment agreement and not necessarily having contracts per se.
Okay, let me address this a bit, and then we'll move on to copyright.
Great.
The statute, it covers you even if you don't have the written agreement, because it's meant to protect the artist. Furthermore, no one can have you sign an agreement that waives your rights under the Art Consignment Act. The Art Consignment Act is very clear that all of its protections are non-waivable. Okay, number two, the handshake. It's trying to get away from the handshake, and it isn't a matter of trust. If I gave my art to Paul or to the Gray Gallery, yeah, I'd feel good about it. But you know something? They're not all that level. And the handshake is not the way business is operated in any other area of the world. I mean, you believe me, the guy who comes and rods out your toilet, you're signing an estimate, and you're signing that bill of sale. And try to get out of your car dealer when you take it in for an oil and lube without signing a document with your name on it and an estimate. The world of business does not operate on handshakes. It just isn't businesslike, and it is a way that galleries tend to, I think, take advantage of artists. That handshake never works to the benefit of the artist against the gallery. At any rate, let's go on to copyright, because that is where we've gotten a couple of questions today, and I think most of you want to hear more about copyright. Copyright has existed for hundreds and hundreds of years, and the purpose of the law of copyright is to resolve a tension. It's trying to resolve a tension between, all of it is designed to incentivize the arts, and even our Constitution, it's to promote the progress of science in the useful arts, and the way you incentivize them is giving artists, the words of copyright is author. It started with writing, and so if you paint a picture, the copyright law says you're an author. That's the terminology. But the artist, it's to incentivize you by giving you what is in essence a monopoly, the rights over your creation. On the other hand, pulling in the other direction, we're trying to incentivize and promote the progress of arts for all of society. And that means you want to build on what has gone before. All art, all creativity, music, film, photographs, whatever it is, certainly writing, is built upon what went before it. So if you're talking about art, you know, the second caveman that scratched on a wall was probably influenced by the first caveman who scratched on a wall. And it's gone down to today. So we're trying to incentivize individual artists to work, and at the same time, incentivize people to build on other people's work. And so there's this basic tension, and that's what copyright law is trying to resolve. And if you understand that, all these kind of arcane laws and rules, you can do this, not that, and that, but not this, kind of fall into place. You can see where the balance is trying to be made. How do you get a copyright? A copyright attaches when you have an original work fixed in a tangible medium of expression. That's all you need. Original work fixed in a tangible medium of expression. What's original mean? Original means that you didn't copy it from somebody else, and that there's at least some small degree of intellectual labor that you put in it. And it is not a mere copy, a perfect copy of what somebody else did. It certainly covers pictorial and visual works of all kinds. What does fixed mean? That's what original work means. What's fixed mean? It is fixed when it is embodied in a tangible form that is perceptible by someone else, even with the aid of a machine, and capable of reproduced. So if you put it on paper or scratch it on a wall or scratch it on a cow or something like that, somebody else can see it. It's capable of being reproduced. I can take a photo of it. I can take a Xerox of it. It is fixed in a tangible medium. It's a little easier sometimes to talk about it in music. If I were to sit down now and just make up a song and just sing it out into the air, it wouldn't be fixed. If I recorded it, if it were recorded on tape or something, or I wrote on the notes, yes, somebody could come along tomorrow or a year from now and look at it and know what my song was. So if you have an original work that is fixed in a tangible form, you have the copyright the moment you do it. So when you make that work of visual art, you have the copyright right then and there. You don't have to register. No one has to give it to you. No one has to know about it. You can paint it, put it in your desk, lock it up. You have a copyright on it right then and there. What do you get when you have a copyright? What are the rights, the basic rights that the owner of a copyright has once that original work with at least a modicum, a teeny bit of creativity, is expressed? Well, number one, oddly enough, the right to copy. The right to reproduce that work and make copies of it is one right. The second right is to distribute it. And distribute is not limited to sell. So if I make a drawing, I can make hundreds and hundreds of copies and stand on the corner and hand them out. If I make a drawing and you make hundreds and hundreds of copies of it and stand on the corner and give it out free, you cannot do that. The right to distribution belongs to the owner, and no one else can do it, even free. Distribution does not require sale. Number three, not the right to public display. It's yours. You can display it in public. 4 doesn't apply so much to you. It's public performance. It's public performance, which applies to music and film and other things, not so much to yours. And the fifth one is something called the right to prepare derivatives. A derivative is a work based on a pre-existing work. So if you make the painting, you can make a derivative of it. It's any additional work where the pre-existing work is recast, adapted, transformed, etc. Adaptation. Those are your 5 basic rights, what you get when you have a copyright. And no one else has it. The copyright owner has it. And I say you have it the minute you fix that in a tangible medium, and you do. You don't have to register it. What does registration mean? Registration means that you literally file it and register it with the Copyright Office, which is in Washington, which is part of the Library of Congress. There are advantages to registering it, although you don't have to do it. If you don't make a whole lot of things, if you're a photographer making 500 pictures a week, it gets very expensive and hard to do. If you're a painter and you do a few oils a year, it's probably worth it. You can do it online. The advantages are it's a public record. It's evidence of the validity of your copyright. You get certain remedies if somebody infringes after you register that you don't get otherwise, but you do not have to do it. It's a good idea to put a little copyright notice on it. You're not going to put it on the face of your painting. Put it on the back side, a little C with your name and a date. That's how you get your copyright. What's it good for? It's good for the life of the creator plus 70 additional years. That's an awfully long time. So if you're 40 and you live to 90, that's 50 years, and now another 70. So they're basically forever. What I want to get to is the kind of questions that I've been getting as fair use. First of all, the copyright owner, the owner of that copyright, has those 5 rights. What I want to interject here is something that I think you know. If I go down to a gallery and I buy your painting from the gallery, pay for it, and take it home, I own that painting. I own that piece of canvas. I own the paint on it, etc. I can do what I want with it. I can burn it up. I can cut it up. I can do almost anything I want. I can hang it in my house. I can probably show it at a local sale, but I don't own the copyright. When a painter, a visual artist, prepares a work of visual art and sells it to somebody else, that buyer does not acquire the copyright by virtue of acquiring the work. The copyright remains with the artist. In order to transfer the copyright, there must be a written contract that expressly says, I am hereby transferring, selling you the copyright in painting number 1, etc., for $10, whatever it is. But just buying the work of art from a gallery or even buying it directly from you, the buyer does not acquire the copyright. Now that has some interesting aspects. I bought your painting. I can hang it, I cannot hang it, I can do anything around I want with it, but I can't do those 5 things. I can't make copies of that painting. I can't distribute those copies. I cannot make derivatives. You can only do that, even though I own your painting and I've owned it for 50 years. So that also impacts the estates of artists. Artists, when they die, must understand that they own copyrights in all their works. May not be quite as important with art as it is we find with musicians, whose music may be played for years and years and years, and they maybe sold their song years ago, but they maintain the copyright. So you still have that copyright. Infringement is where somebody else, without your permission, exercises one of those 5 rights. You own the rights. That person doesn't, and if they exercise one or both of them, that's an infringement of your copyright, violation of your copyright, a breach of your copyright. We use the word infringement. And you have rights in federal court. Copyright is a federal matter. Now, over the years, things would come up in court, in which, this is what happens in courts. Things would come up, and somebody would say, you know, they're using this work, and it's mine. And the judge would look at it and say, yeah, but, you know, under all the circumstances, I don't think it's wrong. I think that what that guy did was really kind of fair. And so over the years, this body of law from judges' decisions called common law grew up, where a whole bunch of rules or circumstances came up where the court said, you know, yeah, they infringed. He didn't have the right to do it. He didn't get your permission to do it. But I think that the public is served by allowing them to do it. I think it was a fair use. Over many, many years, that grew up, And finally, when the Copyright Act was went through a major amendment, which was 1976, they included it for the first time in the written copyright statute. So keep in mind that basic tension. We're trying to encourage individual artists by giving them rights, but we want to make everyone's art available to everyone else to build upon. So fair use is an element of that tension. Yes.
How do you function with fair use as a guide? I mean, like, you know, if an artist wants to reproduce a Gucci logo or have it in the background of a photograph that they're taking, are they culpable? Are they liable? Or is it all fair game?
That's exactly where I am. That's exactly where I am right now. What is fair use? How do you show it? Basically, the question that every artist, you know, people in other fields, performers, entertainers, want to know is how much of my stuff can somebody else use, and how much of somebody else's stuff can I use?
Yeah.
That's fair use. That's the question everybody wants. And I'll start right out by telling you I cannot give you an answer. It's every court that has decided this, from the Supreme Court on has said the same thing. There is no bright line. There is no speed limit. It says speed limit 65, and if you go 66, you're in violation of the law. There is nothing like that. What the statute has done is put forth 4 factors. These are the factors that the court will look at, trying to decide whether, in your case, something is a fair use or not. And again, every case, and all the appellate courts, the Supreme Court have said, you have to look at each case facts individually. And, you know, if you're using, somebody wrote in and said, I like to paint a newspaper cartoon character. I take that cartoon character that everyone knows and I put her in situations that I dream up. Is that fair use? And the answer, a court might say yes. A court right next door might say no, but it doesn't stand as too much of a precedent for the next guy doing it. What are the factors? First, they will look to the purpose and character of the second artist's use. Was it a direct copy, a Xerox, a photographic copy, or does it add something new? Is there a new purpose? Is there a new message? Is there a different character to the work? Does it alter the significance of the expression of the first work, making it something new, making it something transformative? It would not be enough if the second use is only a new way to exploit it. That when they go to explain it, the words are kind of slippery, and it's pretty suggestive. Also, is the second use commercial? If the second use is commercial, designed to simply make money, that's more likely to be an infringement than not. If it's a not-for-profit that takes a picture, I had a case where a not-for-profit agency that dealt with taking care of children in jeopardy, and they took a famous picture of a little boy or something like that, and they wanted to use it in their invitation. And the question is that an infringement? Well, they're a not-for-profit raising money to help kids. That's better than if Hallmark did it and put it on a card it sold for $4. Commercial versus non-commercial. Here's where the purpose and character comes up again. You get the issue of parody or satire. You will get people saying, well, of course I used that first one, but my work, the second year, is a parody. It is a social commentary. That is something that the law wants to promote. Social commentary and all is a good thing, but it's not a simple safe harbor. You walk up to your work and you lick a label and you stick it on there that says, this is a parody. that doesn't get you home free. That is not a monopoly, you know, get out of jail free card. Parody requires, in order for it to be effective, that you use enough of the first work so that people know what it is you're making fun of or commenting on. I can't comment that your picture stinks without using enough of it to show what I'm making fun of or criticizing or making a parody of. So when you watch Saturday Night Live and they're doing a parody of the Sopranos, they have to use enough elements of the Sopranos. They have to look like them, talk like them, etc., so that you know what they're doing is making fun of them. If you've arrived from Mars and never heard of the Sopranos, it would be very flat. So we know that the second use in a parody or a satire has to use certain amounts of the first work. The courts say, okay, but you can't use more than is necessary. How much is that, Paul wants to know? Who knows? It's going to be in the eyes of the judge who decides. Again, they'll look at the good faith, bad faith of your use. If you're doing it in good faith and you're not trying to hurt anybody, that's all right. If you're doing it to injure the first guy and to steal that person's work, etc., they will look askance. A second factor is what is the nature of the original work. The more creative, the more innovative, the more expressive and fictional it is, the harder it is for you to come along and say it's a fair use to take it. If you come along and I write an article tonight about the Cubs game, and you write an article tomorrow about the Cubs game, and a lot of the phrases are the same, and you know, this guy looked lousy, or this guy did the wrong thing, or something, you know, you're not going to get a copyright infringement. When you get into factual things like that, or the weather reports, they're all going to be alike. But if you come up with something totally creative, totally fictional, that isn't around the place, it's going to be harder to claim my stealing that or my using it as a fair use, whether it's published or unpublished. If I take your unpublished work, remember that painting you put in your desk drawer and you didn't go out and sell it and put it in the world? I come along in your desk drawer and take it. That's a lot more culpable than something you've already put in the work. So the second factor, what is the nature of the original work? The third factor is what is the amount and the substantiality of the portion used. The more I take of your work, the more the importance was, the value of the part I took, the less right I have to do that. If I take a little teeny part that wasn't very important, okay, big deal. How much did I take and what's the quality of it? And perhaps the most important of the four factors, according to the courts, is the market effect of what I took. Is what is the effect on your work of what I took? Have I destroyed or damaged your marketability of that work by what I took? If I haven't, I have a lesser culpability than if I really hurt and destroyed what you took. The Supreme Court, just so I'm not, making it up, says that the task of determining what is a fair use is not to be simplified with bright line rules. It calls for case-by-case analysis. None of these four things are absolutely litmus tests. What I'm telling you is it is a very, very subjective thing. Judges will change all the time. The Copyright Office says the distinction between fair use and infringement may be unclear and not easily defined. There is no specific number of words, lines, or notes that may safely be taken without permission. And merely acknowledging the source of where you took it is not a help for copyright. People confuse academic stealing of other people's work from copyright infringement. Just because you say, I took this from somebody else's work, will keep you from being academically at fault, but will not keep you from copyright. Many of you are familiar with what's called appropriation art, Jeff Koons' work. Paul was talking to me about Richard Prince, the Rastafarians earlier. Jeff Koons does this appropriation. He takes ads. He takes other people's stuff. He makes his stuff for it, and people pay him millions for it. Don't ask me why. But it is appropriation work, and he has been in lawsuits all the time. He's won some lawsuits. He's lost some lawsuits. But the difference between him and you, I have a colleague who says he can afford fair use. You can't. So in those lawsuits, for the last one was with the legs, the stockings and the legs and the shoe ads and stuff. Blanche was the name of the case. It probably cost a couple $1 million to defend that case in the district court and then the Court of Appeals in New York. But the co-defendants were Deutsche Bank, Guggenheim Foundation, and Koons has millions of bucks. He can afford to fight that. I have a colleague who likes to say to his clients, you can't afford fair use. So if you take somebody else's work, you got to be ready to defend it if it comes to that. I'm sorry that it isn't, I can't sit down and say you can do this, not that. Anyone who tells you that is not right. Like the Copyright Office said, there are no certain amount of notes that you can take from somebody's music, how many words out of a novel. I actually had somebody come in, it was a gallery, who called me up in panic on a Thursday night. They were setting up for a weekend show and said this artist came in and every single work she brought in is taken from somebody else. We were walking around and we would name who she took it from. It wasn't even one style. And we confronted her about it and she said, I was told that I can take 30% of someone else's work. Well, aside from the fact that I don't think any of you can define what 30% of a painting is it the bottom third? Is it the right-hand third? Is it 1 out of 3 cows? What is 30% of a painting? That she never figured out. There is no such per se rule like that. There's a famous case out in federal court in the 6th District where 3 or 4 or 5 notes of music were found to be an infringement. So I'm sorry I can't give you a good rule. The one thing I can tell you is anybody that gives you a good, hard, fast rule of what is fair use is wrong. Photographs.
Let's move to some specific questions because because we're running out of time and I don't want to keep Paul too late.
Yeah.
And maybe people have been typing in questions, and maybe I'll take them backwards and go from. To what extent can you use a famous person's image in your artwork?
A famous person's image in your artwork, you get into something else. Using someone's image, where I'm not really taking that image from someplace else. I decide to paint, Barack Obama's picture. And I do so. It's different than the famous case that came up where in the AP where somebody literally took the photograph and printed it. You get into the right of publicity, and it's not just famous people. In Illinois, Paul, I could not take your photo off of this broadcast and use it commercially. I can't take your a pretty child I see on the street, take her picture, and all of a sudden it shows up on milk cartons or toothpaste. That's a right of privacy. You have the right to your own look, image, voice, sound, etc., etc. If one of the questions came in was a person who took a famous cartoon character, not a real living person. It was a cartoon character that appeared in a popular cartoon, and this person took that picture and painted this person in some various scenes that the painter thought up. That gets away from right of privacy. A cartoon character doesn't have any privacy, but it gets it back into copyright. That character, as drawn, is undoubtedly copyrighted by the authors of that film, of that cartoon. Is it fair use? Well, you've got to go back through these 4 terms and say it was transformed. One is a cartoon. This is fine art. I've changed it. It has a different message. It has a different this and this and this. The kind of thing that Kuhn says when he takes the scissors and clips out hosiery ads from the paper and puts them in a painting. He says, I've changed it. It's a different message. Maybe she would claim this is a comment. Maybe this is criticism of the cartoon. You have all of those basically subjective problems. And how it comes out, it's going to depend on how the judges look. This last case that Coons actually won with the legs and the shoes was a 2-to-1 decision by the Federal Court of Appeals. The judge below held against him. So there you have 4 federal judges. They split 2 and 2 on whether he was right or wrong. And when you read their opinions, it's so filled with kind of subjective things. I don't think this was meant to be that, and I think what he did is true, and change the message. You'll see it just isn't easy to tell. The other question that Paul sent to me had to do with photographs. It had to do with a person who takes photographs, and some of the content might have been a problem. Photography is a fine art. It's a visual art. It's subject to all of the same rules as painting or watercolors. You sometimes get into the subject matter of the photo. In the particular question he sent in, the photo included a trademark. It might also include copyrighted work. Paul talked about a movie. And, you know, you're walking through the movie and you're in the home of somebody who's having a party, and there on the wall is a painting, and that appears in the movie. Is that a violation of the copyright? Yeah, it is. And when people make movies like that, they go through frame by frame and make sure that every single thing in there is either obscured, or you get a release for it, or you pay somebody for it, or you take it out. And that includes cars driving up and down the street. You pass a McDonald's, you better make sure McDonald's doesn't care that you take it. Sometimes they say, sure, leave it in, but pay me. Believe it or not, film lawyers, they have these big books, and they're 8-9 inches thick, and they go through each frame and make sure there is no violation. When you get to the logo that I think your questioner had today, logos are a little different. You get into the world of trademark, trade name is different than copyright. Copyright protects the author against other people using her work. Trademark is based on something else. It's to keep the public from being confused as to whose goods these are. So when I have a sweatshirt that has the word Nike, or that, you know, the swoosh, you know, that sign that Nike has, that the whole world has, that is a sign to the world that Nike made that shirt, not somebody else. And if somebody else goes out and knocks off these shoes or this T-shirt and puts the swoosh on there, that is a violation of their trademark. Those are called counterfeit goods, and they get taken away, and the guy who did them gets arrested. That is confusing the public as to the source of the goods. Now, you have a painting, and part of your painting is a Nike swoosh, or somebody wearing a Gucci something with those little G's on there, or the word Coca-Cola, or Campbell Soup, or something like that. The public isn't going to be confused that Gucci is making paintings, that Nike is making paintings, or that Campbell Soup made the painting of all those tomato soup cans. There is no confusion of the public, and there would be no violation of their trademark, essentially using it in that way. I've seen many photographs. Somebody came in, about a year ago, and they were showing road scenes, and it's kind of a picture of the side of a road with a lot of stuff in there, and it was a crumpled up beer can, and you could see it said Budweiser on it, a crumpled up Budweiser, Miller, something on the side of the road. He was worried about trademark violation. It really isn't. No one is passing off that painting as being a product of Budweiser, and it isn't disparaging Budweiser. It's simply a can that somebody threw out a window. I also had a case years and years ago by a Chicago artist who came in and wanted to paint a really terrible picture of Mayor Daley taking a bribe. Now, I think you're all familiar with the one of Harold Washington wearing ladies' underwear, and that picture got arrested at the museum. But this guy said, I want to paint a picture of Mayor Daley taking cash from a sly-looking character. And I said, well, go ahead, but watch out for the law of defamation, because that's no different from you printing a flyer or writing an article and saying Mayor Daley takes cash bribes. That's not really fair use. That's not criticizing the mayor that he's not a good mayor. That's calling him a felon. And you can disparage, you can defame people in art. It's very hard to do it. Very hard to do it.
But we should probably wrap this up in like 5 minutes plus or minus.
What do you guys want to know?
Well, somebody asked about, I don't know how relevant this is, maybe we can spend less than a minute on this, the Orphan Act.
The Orphan Act, I've been getting questions on Orphan Act for 20 years, and I'm probably going to get them for another 20 years because Congress apparently has no intention of passing the Orphan Act. What the Orphan Act is this. Creators come along, be they filmmakers, whatever they're going to do, and they say, I want to use this piece of work, this painting, music, etc., etc., etc. But I'll be damned, I cannot find who the owner is. I don't want to break the law. I'm a Boy Scout. I don't want to take it. I want to pay, but I can't find who it is. And I know, sure as hell, as soon as I put this in my movie, somebody is going to come out of the woodwork and sue me. The Orphan Act is designed to protect people like that by, in essence, requiring a certain level of, quote, reasonable search, and I forgot what the details are. And if you can show you made that reasonable search, and the Copyright Office didn't know, or this didn't know, or the last known address, whatever their requirements are. If you make that reasonable search and cannot find the owner, then if you use it and the owner comes out, it's a very limited amount of damages. They can't say, ha-ha, I got you for $1 million. It may be what it would have been worth if you'd known them in the first place, $100 or something like that. So it protects the person who wants to use a copyrighted work but cannot find the copyright owner. It seems to make sense. It has never passed Congress. And what I don't know is who's opposing it.
I'm opposing it.
Well, I mean, you're opposing. You're against that?
Yeah.
Okay. Well, why?
I think you can do a good enough search to find the people in this day and age, and if you can't, you should. I mean, it's the proof of it. The problem I have. But let's not go there. Let's not worry about that for the moment. I think this has answered all my questions. If somebody else doesn't feel like their question has been answered, why don't you go ahead and ask it now?
Yeah. Must be something. You're all looking very strange. I can see you.
Hi, my name's Ken. I don't know if you can hear me.
Go ahead, Ken.
I was wondering about the issue of Chapman Kelly and the Wildflower Works and what came out of that. There's supposedly something beneficial for us artists, our rights.
I'm not so sure. That's a case that we are actually handling. We got Chapman the attorneys who have been handling that case through trial and appeal. And it generated, what happened is that the Chapman-Kelly Garden in Millennium Park was basically, you know, messed up by the city. The opinion that came out of the Seventh Circuit Court of Appeals was really a terrible opinion. And it said some things that seemed to make absolutely no sense. And I don't think much good came out of it for artists, certainly not those who want to make art out of landscaping. Because it said, well, it's not really original. It's not really original because it grows. And it just took some standard copyright principles and said they don't apply to things like that grow. It was really kind of a miserable opinion. If any of you have seen like the work that Kelly had out there for many years, or other people who do real interesting artistic landscaping, you know it is creative and it is artistic, and it should be protected. But the Seventh Circuit was a really lousy opinion. I spoke to him not long ago. We got him the attorney. He has excellent attorneys. One of Chicago's very best law firms is representing him, and free. And they're thinking of trying to appeal to the Supreme Court. It wasn't a real good opinion for artists, I'm afraid.
Okay, well, thank you. Yeah, I'm friends with Chapman, and I worked on that back in the 80s, and I thank you for the update on that.
Well, he's a fine guy, and he should have won, but didn't.
Anybody else? Oh, wait, Alyssa, you had a question.
I have a question. Hi, Bill. I'm actually a photographer, and so I do commercial work and fine artwork. The commercial work, I will subcontract people to shoot along with me. Do they still own the copyright, or does my studio own it? And then if I'm doing fine art and I have a whole crew on site working on a project, if someone goes up and is playing with the camera and it actually happens to be a really good photo, is the studio under, does the studio hold the copyright, or is it the person who pushed the button?
Okay. All right, you've been given a photographic assignment, and you retain somebody to help you and take some of the photos, etc. Okay?
Correct.
This is a good example of, we can argue about this forever, or we can preclude the whole thing with a very simple one-page agreement between you and these photographers you hire that says, I, Alyssa, or Alyssa's studio, are retaining you for X dollars to take the following photographs. Line, 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 line. It is understood and agreed between us that the copyright will belong to Alyssa's studio. It will not belong to the photographers, and the photographers hereby assign any and all rights they have to those photographs, including copyright to Alyssa. So whether who would have them, you don't care, because they've signed away all those rights for you. One page, you can call us, we can deal with it and help you with that. It's an argument you don't want to win. It's an argument you don't want to fight. It's an argument you want to foreclose by having them sign a release and a transfer to you of all the rights before they take the picture.
All right, thank you, Bill.
It's the easy, cheap way to do it.
I think we need to wrap this up really shortly. I think we can take one more question if there is one. Somebody? Cool.
Cool. Thank you all.
Bill, I think this has been really wonderful, and you've provided us with a wealth of information, and it's cleared up a number of questions that I've had for a while. And I really appreciate your insight and, you know, the straightforward directness of your comments. It's been really good. So I'm going to unmute everybody so that we can all echo the thanks together. So, thank you very much.
Thank you.
Thank you. Thank you.
All right, gang.
All right, I'm gone.
You're gone. Thank you so much for participating, Bill. Good night.
Thank you all.